Who's Mr. Gamzo? Does he want to get this? Well, we'll find out, I guess.
There's going to be someone come up to introduce him anyway.
All right, I'll put this in.
Okay, could everyone please take a seat? We are about to begin.
Can I give this to you already? Just because you're the main speaker.
Yes.
Okay, I'll get it.
Because I'm not at all good at ad-libbing and I never got around to writing anything. I can pick up the mic, he says. Okay, how's this? Am I making any noise? Okay. I mean, I think you probably heard me before, but yeah, I'll probably forget to yell after a minute. So, okay, but I want to welcome everyone here and thank you so much for coming. I think it's so important, and I'm really excited, especially that we have so many people here this year. This is a record-breaker year in terms of people who've signed up and are coming. We're at, I think, probably about 170 this year. Is that right? Over 170 now, and that's easily. Well, I think our last biggest year was in New Mexico, and that year we had that many people because we had some really bad press. There were pedophiles coming to New Mexico, and oh my God, sex offenders are showing up in Albuquerque, and we need to protect our children. I mean, we got a lot of new members down there, and nothing happened, and they were so shocked. But anyway, this year we have a lot of people because there are a lot of people just plain interested, and we've come from all across the country, and we have a lot of media here because they care. And I think you'll see a big difference in terms of that this year. So the media that you do see here, they're not here for sensationalism. They're all here because they've actually, most of them been vetted. They get the issues, and they're here to cover sympathetically. So I think what we do see come out of this, I think it's going to be really, really good. I will say one thing, I think, related to the media. I know a lot of people are concerned. We've all had bad experiences with media. I'm right up there with you. I just want to make sure everybody understands that the green on your badge or the red on your badge, nobody is allowed to walk up here and stick a microphone in your face, okay? Against the rules. If anybody tries, tell them no. Go to the front desk. I mean, if they sneak past us. The whole purpose of those red and green is if they're waving their little camera around, just kind of doing group shots, and they're supposed to do that from the back. But if somehow or other they catch somebody's face in there and they've got a red on, they need to either not use it or they need to, fuzz out your face. Yes, ma'am. Right. Okay. So Judith is. Yeah. So Judith is saying she's here. That she's doing some research. There are a couple other people that are doing research as well. If they walk up to you and ask you permission, that's different. Of course, and then you'd be off the record, or you can say whether or not you're private or whatever, and that's then it's totally up to you if you're comfortable with that person, certainly. But just, random shots are not allowed, and nobody should just walk up and start asking you questions without getting your permission. So that's good. So back onto what little script I have. I just want to encourage everybody to learn and to network and take your time here to get to know other people. It's the only chance many of us have all year to really mingle with other people who get the issue and really understand what life is like and what the problems are, where you don't have to explain, you don't have to worry. And so take full advantage of that. Don't be shy. We're all family. And we hope that you'll find also some inspiration to get involved if you're not already involved. Look around on badges. You can see people who are volunteers or who are active leaders. Ask questions and mingle. And with that, I thank you very much. I'm going to hand it back over to our MC of the day, Paul Shannon.
Thank you, Brenda.
Thank you.
So, I know everyone wants to hear our first speaker, Jeffrey Gamzo, but just some housekeeping details. Most important, of course, is the bathrooms are across the hall. You'll notice that we have certain sessions of workshops. When a workshop is said to be in room A, that's this room. When it's said to be in room B, it's in room 205 upstairs. What? Yes, we all know how kind of disruptive cell phones can be in these types of situations. So if people, especially in this room, could turn your cell phones off unless you have a real emergency that you're dealing with. Snacks are available thanks to our wonderful volunteers here right outside in the hall. For those of you who have been at the hotel, there's a map at the front desk. On the back of that instruction sheet, I should say, on the back of that is a map of the area around the hotel with where restaurants are and all of this. So I think with those preliminary announcements, we can get going. I just will let people know along the lines of journalists who are here. John Sarna, who's been working with Arkansas time after time, our chapter, our affiliate, our connection down in Arkansas, does a program for Little Rock Community Radio. John, you want to just stand up a second? The name of his program is It Could Be You, and he would very much appreciate anyone who's willing to be interviewed for just a few minutes anytime during the conference for his program. He would appreciate that, and we appreciate John being here. So, with that, what we'll do is intersperse other announcements throughout the program, but I think we can get going here. I mean, the reality is, some of us are here because of the suffering that this war on people labeled sex offenders is causing to you and your families. Others of us are here because of the just being outraged and frightened by what this war is doing to our country and how it's undermining the possibility of community and redemption in our country and really setting us against each other. And this is not the way any of us want to go. You're going to be hear a lot of important information that we can use. You're going to be talking with each other. Let's hope that after this conference we can come out of this really committed to keeping up the good fight, realizing that it's not only our lives that are at stake, but the future of our country and the type of society we're going to live in. So with that, I just want to welcome Barbara Gail from Georgia, a retired lawyer from Georgia, who will introduce Jeffrey, our first speaker. Barbara?
It's almost as hot here as it is in Georgia. We have all that humidity, though, that just kind of oozes down from the sky that makes it a little more interesting. My name is Barbara Gail. I'm a retired attorney from Georgia, and I have the wonderful opportunity to introduce Jeffrey Gamzo, who is going to be speaking to us. Mr. Gamzo is an attorney. He graduated in 1987 from Texas Tech University School of Law, and he has practiced in Texas and Ohio and is now an assistant public defender with the Office of the Cuyahoga County Public Defender. He has spent his entire career doing criminal defense. I did that for a while myself. It's a wonderful, wonderful way to help people. From 2000 to 2004, he served on the Ohio Public Defender Commission. And from 2004 to 2009, he was the legal director of the ACLU in Ohio. He has represented men and women in state and federal courts in Texas and Ohio and in the United States Supreme Court. He was lead counsel in State versus Bodicki, and I hope I pronounced that right, Jeff, the case in which the Ohio Supreme Court first found portions of Ohio's Adam Walsh Act unconstitutional. Because of the acoustics in this room, he is willing to take questions. I've torn some paper, and you have some of this in your folder. If you would write your questions and just kind of pass them up to me, I will get them to him. He is willing to answer any of your questions. And if there's anything else that you need, if you just grab me, and I'll try to get a note to him. And with that, I would like to introduce, he says I'm not close enough, Jeffrey Gamzo. Thank you.
Thank you. See, I'm supposedly mic'd up here too, and the double mic. Can you hear me in the back? Yeah. Okay. There's a PowerPoint here, and frankly, don't worry about it. But we'll try and get it to kind of function at some point along the way here. But I want to tell you a little bit about me. And first, I got to say, I hate hot weather, but I lived in Texas for 12 years, and I went to law school here, and it's always kind of nice to be back in Texas. Whatever the excuse that brings me down here. But this is important. And law's my second career, but I've been doing criminal defense actually since my first year in law school, so since 1984. So I've been doing this for now 31 years. And there's nothing that is ultimately more important to our culture, our society, than, this is not me, this is not an original thought of mine, but the way we treat the people we most hate. And unfortunately, and not with cause, but in reality, the people that we most hate are not necessarily the people who do the worst things. They're not necessarily the worst people. But they are the people that we have decided as a society need to have their lives destroyed. And unfortunately, you're those people in large part, or one group of them. And the best we can do on a daily basis is try and hold back the dam. And I want to tell you some about how we've done that, and how we can try and help you, and why we can't help all of you. And that means a little bit of reality testing about the way this system works. If you're charged with a crime in the United States, thanks to Clarence Gideon, you are entitled to a lawyer. That's the bottom line. You're entitled to a lawyer to defend you up to the point where you are convicted or found not guilty, for that matter. But assuming you're convicted, if you're charged with a crime in this country, you are entitled to a lawyer. You can hire one if you can afford to. That doesn't necessarily mean you're going to get a good lawyer. There's a lot of bad lawyering out there. There's an awful lot of bad lawyering out there. And there are people who go out and they have really good public defenders, but they don't trust public defenders because we work for the government, right? And you know, I mean, who pays my salary? I am a state public defender. I'm a county public defender in the state of Ohio now. My salary is paid out of the tax dollars of the people who want to lock you up forever. And you look at that and you say, and lots of my clients say, why would I trust you? You're being paid by the people who want to put me away. And so people fire their public defender. They've managed to raise money and they go out and they hire some guy down the street. There are really good lawyers in private practice. There are really good lawyers who are public defenders. There are really bad lawyers in private practice, and there are really bad lawyers who are public defenders. But one way or another, if you're charged with a crime, you're entitled to a lawyer. You can retain one, or you can get one appointed by whatever system your jurisdiction has for appointing them, whether it's appointed counsel or contract lawyers or a public defender system or whatever. You're entitled to a lawyer. And if you end up being convicted of a crime, and most people who are charged with crimes end up being convicted of something, not necessarily exactly what they're charged with, but they end up being convicted of something, whether they're guilty or not, you are then entitled to a lawyer to appeal that decision. And if you lose there, and the vast majority of appeals are unsuccessful, and appeals almost never have anything to do with whether people are guilty or innocent, they have almost nothing to do in the ordinary course of things. There are exceptions, but in the ordinary course of things, they have nothing to do with whether your sentence is unreasonable or unfair. They have to do with technical mistakes that occurred during the proceedings below. Did some lawyer ask some witness a question that was improper and the judge said it was okay? Or did the judge make some ruling that was just wrong? That's what appeals are about. They're not about whether you did it. They're not about whether things were fair. They talk about it as being about fairness, but they're not about fairness. They're about technicalities almost all the time. And if you lose your appeal, then you're not entitled to anything. You have run out of government guaranteed by the Supreme Court, by the Sixth Amendment. You have run out of your right to appointed counsel. Your state may provide some small funds for lawyers to do some additional things, maybe if you jump through the right hoops. In Ohio, we have a system of post-conviction relief, which is our version, more or less, of federal habeas corpus, which is, if you can convince a judge to appoint somebody to represent you in state post-conviction relief in Ohio, which is how you try and get at things that didn't happen at trial. If you can convince a judge to appoint a lawyer to help you, in most counties in Ohio, Ohio has 88 counties and 88 different schedules for paying appointed counsel. The typical maximum fee that lawyer can get is somewhere between $350 and $500 for maybe hundreds of hours of work. How many lawyers in private practice are willing to do that job? Do I hear none? Which is why we have some organizations that do sometimes fill those gaps. My office, I'm salaried. I get paid a salary. I can take on some of those cases in cases out of my county, but I can't do them all because I've got this other job that I'm required to do. I'm required to represent people who are appeal. I'm an appellate lawyer. I am required to represent people who have been convicted and are challenging their conviction first round, the part where they're entitled by the Constitution to a lawyer. I have to do those cases. That's my job. Now and again, I can look at somebody else and say, you've got a really good story and a really good argument, and I can take on your case. But I can't take on his case too, and hers, and that one over there. I can't do it because I've got this load of cases I absolutely have to do. So what makes your case special that says this is the one I can take on? And the answer is almost never. Almost never. I almost always have to turn those cases down if it's just about you. And that's really unfortunate, but that's true for me in the Cuyahoga County Public Defender's Office. That's true for the people who work in the Office of the State Public Defender, who have exactly the same problem I do, except they've got people from all over the state going, hey, I'm the special one. No, you're not. Look around this room. You're all special. And so are all those folks out there who've been convicted of crimes, whatever their crimes are, they're all special to them. They're all special to their families. They're all special to the people who are suffering for them. But they can't all be special to us because there aren't enough of us with enough time. The Ohio State Public Defender, which has been operating on, frankly, not nearly enough money for decades, was just announced. The state budget has to be signed by the governor on Monday, and the latest version, which is now passed both houses of the state legislature, cuts the funding for the state public defender by $400,000 for the next fiscal year. They're going to take on more of these cases? They're going to take on fewer. There aren't the resources. Private counsel can't do them. Public counsel can't do them. I was the legal director of the ACLU of Ohio for 5 years. The ACLU does not ordinarily do criminal cases, takes on a few now and again, and takes on some collateral side litigation. And we got involved in some of these cases, but it's the same problem. When I was legal director, we had 2 lawyers, me and a staff attorney. And the 2 of us had, the ACLU, we were litigating about 30 voting rights cases. We had civil rights cases of one sort or another. We had free speech cases. And we tried to represent other things. There's only so much we can do, and the answer is they have to be the special folks. And you're all special to you, but you're not all special in the sense that we needed. So what I want to do is I want to tell you a story. I want to tell you a story about what we can do, a story about what, in fact, we did do. And if I can make this work, and I can't even see what's up there, so I've got to try and bring it up on my computer here so I can see it. Yeah, I know I can turn around, but but I need to have a better handle than that. So hang on a second here. Thank you.
You might check the other side as well.
I would certainly have done that. And I really appreciate it. Okay, so let's see if this is going to work. So I want to tell you a story. And hey, how about that? Cool. It's about the sex offender law in Ohio. Our first Sex Offender Registration Notification Act in Ohio was enacted in 1963. I was 14 years old. I was living in New York City. I didn't know anything about it. I still actually don't know anything about the 1963 law, but it's there. It was there in 1963. And I got to tell you, the fact that I don't know anything about it means it probably wasn't too bad, as these things go. It wasn't a good thing. They're never good things. But it probably wasn't too bad because people weren't kicking and screaming about it decades later when I first got to Ohio. And they would have been still if it were really outrageous. But what happened next is 1996, or 1996. 1996, and by then I was in Ohio, and by then I was practicing law and had been for a few years, Ohio enacted Megan's Law. And there ought to be a law I don't actually favor more laws except for this one. There should be a law that makes it a crime to name laws after people. It's always a bad idea. And in 1996, we enacted Megan's Law, and one of the provisions of Megan's Law in Ohio was that it was retroactive, right? And so if you were, and the details we spent years ironing out the details of what exactly this meant, but the way it worked was that if you were convicted of a crime after Megan's Law, of a covered crime, you would be either classified as a sexually oriented offender, an habitual sexual offender, or a sexual predator, depending on a kind of goofy analysis of how dangerous you were. Had nothing to do, in the real world, it bore almost no relationship to danger, but at least that was the idea. There was a pretense that it was about dangerousness. And we were going to keep a better eye on the more dangerous, but that's going forward. The problem is, it also applied to people who were already doing time, who'd already been convicted of crimes, who'd done things years ago. And so, all those folks, and there were a lot of them, started finding themselves reclassified, or classified as a sexually oriented offender and having to register once a year for the next 10 years originally, I think it was, or an habitual sexual offender having to register every 180 days for 20 years, or a sexual predator every 90 days for the rest of their lives, and then there were all these other collateral issues, and maybe there was community notification in some of these cases, and maybe there wasn't, and forget how bad it was for all the people going forward. What happened to all these people in the past who suddenly had to start doing this stuff? And they had to be reclassified, and that meant court hearings, and that meant, well, were they entitled to lawyers? And we started arguing about that, and lawyers in private practice all over the state started litigating these cases. And county public defenders, where we had them, started litigating these cases, and lawyers who were retained, and lawyers who were appointed, and the state public defender. And ultimately, decisions went mostly against you, because after all, this is all about terrible people, and anybody who gets caught up in the law must be a terrible person, because if you weren't a terrible person, you wouldn't have gotten caught up in the law in the first place, because you would never have done anything wrong, whether you did or not. So there are people all over the state who are trying to fight this one way or another, and there are lots of people who can't try and fight it because they don't have any money and they can't find a lawyer, and we've already been through this. You don't have the hundreds of thousands of dollars to hire somebody to do the job, and maybe you did, but you hired a bozo, or you got some public defender who's going, I just can't take on another one of these cases. But the cases went on, and eventually one of them went to the Ohio Supreme Court, State versus Cook, and because it was in the Ohio Supreme Court, finally, on the question of retroactive application of Megan's Law, because it was in the Ohio Supreme Court, yes, turn off your phones, everybody. I don't even know how to turn off my phone here. There we go. My partner became a federal judge a few years ago, my former partner, and when Senator Charles Grassley was speaking on the floor of the Senate opposing his confirmation as a federal judge, because after all he represented people like, people like you folks. Grassley was speaking on the floor of the Senate, and his phone went off. We were all watching this on C-SPAN, and his phone went off, and it sounded just like my partner's phone. And we thought, oh, Jeffrey's getting a call. No, it was Senator Grassley who was getting a call. The difference is he answered it. So, So the State versus Cook goes into the Ohio Supreme Court on the question of retroactivity, and okay, it's there now, and they're going to decide what Ohio law is, and this is important. So at this point, then the Ohio Association of Criminal Defense Lawyers, an organization of which I am currently president, the Ohio Association of Criminal Defense Lawyers filed an amicus brief, a friend of the court brief in the Ohio Supreme Court, and said, hey, this shouldn't be retroactive. Support Cook. And the Ohio State Public Defender filed an amicus brief in the Ohio Supreme Court. I filed an amicus brief. I was in private practice at the time, but I did as a volunteer. I filed an amicus brief on behalf of the American Civil Liberties Union of Ohio. And we all climbed in at the last minute, frankly, on behalf of Tony Cook, and we lost. And maybe we would have lost anyway. There's no way of saying what might have happened, but that's not the way to do things. The way to do things is not at the last minute in an emergency to jump in and hope that you can save the sinking ship. I think I'm mixing my metaphors. It doesn't matter. That's not the way to do things. But it's what we did. 2 years later, State versus Williams. This time the issue was community notification. Once again, all these cases had been percolating up. Williams' case got to the Supreme Court. Everybody files amicus briefs. Everybody jumps in at the last minute. Gee, community notification is just fine, says the Supreme Court. Next year, State versus Thompson. There are more ways that Megan's law is constitutional. People keep trying to think up new things. They keep going to the Supreme Court. The Supreme Court keeps saying, oh, no, that's okay, too. And we're winning some technical fights along the way. The Supreme Court said once your prison term is over and you're not on probation and you're not on paper and the government has no control over you, then the Ohio Supreme Court said you can't, if you're in that position and have not yet been reclassified under Megan's law or classified under Megan's law, you can't be. Okay, that was a win. It was actually a win that's helped a lot of people over the years. But frankly, it's a pretty small win in the scheme of things. And it gets to be a smaller win as time goes on. So we win the odd case here and there, but basically we're losing. And then 2003, Megan's law gets a lot worse. They amended it. And they made the registration requirements harsher. You had to give more information. More people were put on public registries, and more community notification was sent out. And the law got a lot worse. And now we're going to take a break from Ohio for a minute and go to Washington, where in Smith versus Doe, the U.S. Supreme Court said that Alaska's version of SORNA is civil, not punitive. Oh, no, this isn't about, nobody gets punished. Huh? You're not being punished just because you're just because your next door neighbors are burning down your house. That's not, no. The Alaska Supreme Court, by the way, later on said, you know what, we don't care what the U.S. Supreme Court said under the federal Constitution. Under our Constitution, this is punishment, it's punitive, and it can't be applied retroactively. But that's not what the U.S. Supreme Court said. And then in Connecticut Department of Public Safety versus Doe, the U.S. Supreme Court said it doesn't even matter whether people are dangerous. We can have a system that has nothing to do with how dangerous you are. That's the pretense. Remember, that was the pretense in Ohio. Right? The more dangerous you are, the worse, the longer you had to register, the more often you had to register, the more likely you were to fall into the category of people who were going to have the neighbors notified. And, but Connecticut had a different system that wasn't based on any calculation of individual danger, but was based on the particular offenses that people committed, and the Supreme Court said, oh, that's fine. We don't care about that. There's a system, that's all we really care about. You're terrible people, and so they can do whatever they want to you. The Constitution doesn't care. But back to Ohio, and Megan's Law, amended in 2003. In 2005, we're back up challenging the amended version of Megan's Law. Once again, the same thing. Individual lawyers take cases, they go to the Supreme Court, and this time, because the law has gotten really significantly worse, and also because the personnel on the Supreme Court has changed over the years, this time the Ohio Supreme Court has seven justices on it. You need 4 to win. They don't have to agree about anything except that you win, but you need 4 of them. And suddenly, in State versus Ferguson, we had 3. And we thought, wait a minute. Okay, we didn't win, but we got 3. Things are looking up. We've never had 3 before. We had 3 of them who said, this is punitive under Ohio law. Forget what the feds say. This has gotten so bad now that it's punishment. They'd always said before, no, it's not punishment. It's fine. Now 3 of them said, this is punishment. Well, that's great, because if it's punishment, then it can't be imposed to people who did whatever it is they're supposed to have done before it became law under the federal Constitution. But that means if we do somehow manage to win a case on that argument, it's going to go to the U.S. Supreme Court, which doesn't think any of this is punishment. So we've got an opening, but a problem. And Ohio does not have an ex post facto clause in our Constitution. We do not. We do not have a clause that says you can't do that. What we have is a different clause. We have a retroactivity clause in the Ohio Constitution. The retroactivity clause in the Ohio Constitution says any new law applies only going forward. It can't be retroactive unless the legislature specifically says it's retroactive. And if the legislature says it, well, then that's good enough. But the presumption is that it's not. Just kind of stick that off to the side for a second. So 2007, there we go. 2007, Ohio becomes the 3rd state to enact the Walsh Act. I think it's the 3rd state. We jumped on the bandwagon in a hurry to enact the Walsh Act because Congress had said when they enacted this, if we appropriate money and you enact the Walsh Act fast enough, you'll get 10% more of the money if we ever decide to appropriate it. If you enact it a little more slowly, you'll only get 5% of that money if we ever decide to appropriate it. If you take longer, you'll get just a fair amount of it, and if you don't enact it, you won't get any of that money if it ever exists. Ohio, looking at this 10% bonus, says, we're in! And so we became the 3rd state to enact the Walsh Act. In 2007, when we did that, the Walsh Act actually had 2 effective dates, our version, July 1, 2007 and January 1, 2008, for different parts of the law. In early 2007, I was at the time the legal director of the ACLU of Ohio, and we got together with people from the Office of the State Public Defender in Columbus, and an organization in Cincinnati called the Ohio Justice and Policy Center. And OJPC, the Justice and Policy Center folks, had been working in conjunction with me, actually, in the ACLU, on one of the things that happened in the 2003 amendments to Megan's Law was they enacted residency restrictions. Can't live within 1,000 feet of various places. They've gotten worse over the years. And some individual communities said, 1,000 feet, that's too little. Let's make it 1,500 feet or 2,000 feet. But we'd been working on some of those cases with the Justice and Policy Center folks. And when the Walsh Act came in, the ACLU and the Ohio Justice and Policy Center and the Ohio State Public Defender got together and they said, we've got to do something about this. Not the way we'd been doing it before, which is climbing in at the last minute, which is coming in after the fact to try and fix whatever mess we've created along the way. We need to try and find a way to deal with these things up front. And this law is going to take effect beginning July 1 of 2007. And frankly, and here's what's going to happen. Thousands of people are going to be reclassified from whatever their classification was under Megan's law to their classification under the Adam-Walsh Act, because it's got a different system. The Adam-Walsh Act is an offense-based system, right? Doesn't matter whether we abandon any pretense of this theory that we can predict who's going to be dangerous in the future or not. We just say, everybody's dangerous. So we're going to just crank up everybody's sentence based on what they happen to be convicted of. And we make the conditions of registration and notification more onerous. They last longer for people who are not, well, if you're tier 3, it's forever. But the time periods for lesser offenses get cranked up, and the amount of information that gets put on websites gets increased, and more neighbors know about it, and it's worse. And we think we had 3 votes for punitive under Ferguson. Or under the amended Adam-Walsh Act, or the amended Megan's Law. This is a whole lot worse. Maybe we can get 4. And personnel on the court has changed again, and maybe there's a little bit of a window here. But we don't want this to ever take effect retroactively. We're not talking about going forward now. We're talking about applying to people who've already who are getting reclassified. And maybe there's a way to take that down. And maybe there's a way to stop it before it takes effect, which would be really cool. So we put our heads together, these organizations, and we said, we need to find a case that we can bring right away and try and get to the Ohio Supreme Court and get the Ohio Supreme Court to agree to hear it, because it won't have to agree to hear it, and then stop the law before it happens, before it takes effect. And so we started looking around and trying to figure out, get 3 organizations, a lot of smart people together, and organizations that can devote the time to this, right, to find the right cases. We don't want to find cases of people who are easy to hate. We want to find cases of people who are hard to hate. So that, for instance, one of the cases we looked into taking on was a guy who came to me who had been convicted of having sex with his girlfriend. She was 14, he was 19. This was some years earlier. They were now married, had 3 children, had been living happily together and nicely together for a long time, and he was facing a change from a 10-year registration requirement, which he should never have had in the first place, because this is just silly, to a lifetime destroying his family. And we thought, okay, there's a good case. And he said, I can't take the publicity. You do this case about me, and I'm going to be splashed all over the front page of the newspaper. I can't do that. Okay, he's out the window. But we started looking around for the right case, for the right person, for the right case, to be able to bring a case up. And, okay, interruption. The idea was to control the litigation. Right? This is what I call it the Marshall Plan. This is what Thurgood Marshall put together when they were trying to arrange to stop segregation in the public schools. You look for the right cases. You try and control the litigation so that you don't have a bunch of people out there doing individual cases that screw things up, where the wrong cases get to the high court. You want to have the right cases go into the high court. So you want to control the litigation. You want to be the people who are doing the lawyering because you know you'll do it right. You want to cherry pick the cases because you want the cases that are appealing somehow, and you want to count to 5. 5 is when William Brennan sat on the U.S. Supreme Court, he would tell his new law clerks who were helping him, fresh out of law school, he would hold up his hand and he would say to them, see what this is? This is 5. With 5 votes, you can do anything around here, because 5 is a majority. And that was the goal. And that was our goal, except we wanted to count to 4, because 4 is what it takes in the Ohio Supreme Court. So here we are in our coalition, the Ohio Public Defender, the Ohio Justice and Policy Center, the ACLU of Ohio, and later on, the Cuyahoga County Public Defender, who I now work for. But they weren't part of this in the beginning. It was statewide at the beginning. Only later did we bring in Cuyahoga County. And what we found, here we go, what we found was a person named King in Dayton, I think it was Dayton, and we brought a couple of different cases involving King, hoping that we could kind of jumpstart everything into the Ohio Supreme Court. It was the first thing we did as a group after one of us found this case. Ohio Supreme, and what we said was, look, you've got a law here that's about to take effect that's going to result in thousands of lawsuits around the state. No question about that. It's going to affect thousands of people. We don't know how many thousands, but there are going to be thousands of lawsuits. They're going to get all kinds of different rulings. And eventually, you're going to have to answer the question of whether this is constitutional. Why don't you do it now and shut this down? Why clog the courts, mess things up? Let's find out. And the Ohio Supreme Court said, no! Why would we do that? Why would we want to take care of this now? Don't be silly. The state attorney general said, thousands of cases? Nah, we can handle that. That's no big deal. So, okay, we can't do that. Next stop, the law's about to take effect. We, and this time we bring in the Cuyahoga County Public Defender, he becomes the 4th member of this group, we go into federal court. On behalf of John Doe, who is looking for another power source, on behalf of John Doe, we go into federal court, and we sue the state attorney general, that's Dan, Mark Dan, shortly before he lost his job for hosting sex parties. Honest to God, sex and pizza parties in his apartment in Columbus, really with his staff there. It was... really, you can't make up these stories, you know. My computer's fine.
Are you sure?
Well, yeah, I guess it can't hurt to plug it in. But but so we sued Mark Dan because he's the state attorney general, and he's the one who's going to have to reclassify everybody, his office. And we sued. Ohio has 88 counties, and the enforcement of the law is going to happen individually by the sheriffs of each of the 88 counties and the prosecutors of each of the 88 counties. So we sued the 88 county prosecutors in Ohio. In one lawsuit in federal court, and said, Judge, stop this. Now, we knew we weren't actually going to win in the long run in federal court. We did not want to have the law actually ruled on in federal court because we'd looked into the federal courts and we knew we would lose. But we thought we might be able to halt things for a while. We were wrong. Didn't work. We lost in federal court. But what we had at this point was a group of 4 organizations and a bunch of really smart lawyers, and then me, but a bunch of really smart lawyers trying to think of ways to work together to control the litigation, to cherry pick the cases, and to find a way to get to 4 in the Ohio Supreme Court. And the problem was, see, there were all these other cases being brought. Still, Why? Because there are thousands of people around the state who are in desperate situations, who are being reclassified. Some of them can afford to hire lawyers, some of them can't. Some of them are getting appointed lawyers. Some state public defenders, or some county public defenders are working on them. Others aren't. Others can't get help. Some people don't want to sue because they know if they file a lawsuit and they're in a small community, say their name's going to be in the newspaper, and there's enough about them to begin with out there in the world, and they certainly don't want to be even more, and they'll see what happens. And there are lawsuits all over the place. Some are being brought by competent lawyers, some of them are being brought by incompetent lawyers. We're trying to put up on the state public defender's website, there is a whole load of information about how, here are challenges that are being made, here's what the courts are ruling, here are copies of complaints that have been filed, so you can try and steal some good stuff, other lawyers around the state. We want you to be doing this. If you're going to be doing it, we want you to be doing it well. So we're trying to give you the resources to do this well. But what we really want is we really want one of us to have your case, to have the case that goes up. We want the case that goes up to be a case that's represented by somebody from one of our organizations as lead counsel. Because that way we know we will be able to raise all the arguments we want to raise, all the ones we can think of. We know that we will litigate it, we think, well, because we think well of ourselves, and we will all work together at every step along the way to see that it's done right. And the first case that happens, a bunch of cases get to the Supreme Court, and we just kind of let them get there. And we all ignore them. Our hope is that the Supreme Court won't take them, because we want them to take a case that one of us has developed. And the first of those cases that gets to the Supreme Court, that they're offered the opportunity to take, is Bodike, which is how you pronounce his name. Is Bodike's case. There's actually three guys who they got consolidated because they raised the same issue in a trial court in Ohio and then in an appellate court in Ohio. And I actually got brought in after the trial court ruling. The lawyer said, hey, I'm taking this case up on appeal. ACLU, will you do this? And I looked, and he'd done all the right things, and he'd set it up right, so I took on the case then in the Court of Appeals. And we lost in the Court of Appeals. But it became the first case that any of us had to go to the Ohio Supreme Court. And you begin your petition, because the Ohio Supreme Court doesn't have to hear these cases. They get to pick. They get to cherry pick. Your request for them to hear the case, in Ohio we call it a memorandum in support of jurisdiction, begins with a section that's not called, but should be, why you guys should waste your time on this case. And the opposition is, no, you shouldn't waste your time on this case, this is trivia. But I had the why you should waste your time on this case. And the first line of that section, and I can't take credit for it, the line came from Jay Mackey at the time, an assistant state public defender. Jay said, here's what you want to start with. You want to start with, this is the case you should take. And it was. And this time, unlike all those other cases that had been up there, we had, I was lead counsel, and we had, just because I happened to be, and we had amicus briefs in support of why you should take this case from the Ohio Justice and Policy Center, from the state public defender, from the Cuyahoga County public defender, from lawyers who had, including me, argued lots and lots of cases in front of the justices of the Ohio Supreme Court. So they kind of knew us all and knew that if we were saying, this is the case you want to take, maybe it was. And they knew us and knew that at least we would present it well. So if they're going to make a decision, I'm making this up, I don't know what they were thinking, but this was our thinking. If they're going to take it, maybe they can see this is really a good case to take, to resolve this mess. And by now there are thousands of lawsuits litigating all over the state, so it's not like we can say, oh, it'll be sure to happen. Now they know it's happened. So they agreed to take it, and we all did our briefing, and we put our heads together, and we made all kinds of arguments. And they scheduled a day for what we've all referred to as Sex Offender Day in the Ohio Supreme Court on the same day in November of 2010, I think it was. We argued State versus Bodike, Chenacki versus Cordray, and In Re DJS. DJS was a child case, was a juvenile sex offender case. Chenacki was a question of whether if you have been reclassified under the Adam Walsh Act, do you have a right to an attorney to challenge that reclassification? And mine was all about whether you can be reclassified in the first place. And we raised, I say I, but really it was we, because we all put our heads together in doing this. And we raised, something like 7 reasons why retroactive application of the Adam Walsh Act was unconstitutional. And we got amicus briefs from organizations across the country, and we had an amicus brief that was written by lawyers from a big law firm in Columbus, Ohio, which is the capital of the state, and which the Ohio Supreme Court could say, oh, we know these guys. These are responsible lawyers. These are the people we play golf with every day. They're not going to sign on to something that's really sleazy. And it's strategy, folks. The idea is to win. And so it's time for oral argument. We're going to have these 3 arguments on the same day. I'm going to argue Bodike. I'm giving 5 minutes of my time. You get 15 minutes to the side in these arguments. And I'm going to give 5 minutes of my time, which is an awful lot. I'm going to give 5 minutes of my 15 to a lawyer who's been out of law school for like a year and a half, has never done anything in any court before, but her name was on the amicus brief from the big fancy law firm. And I wanted this nice, wholesome-looking young woman to stand up and say, I am so-and-so from the firm of, so that they would look at her and go, see, oh, gee, it's not, they really do have a big law firm here on their side. And she was terrible. She was completely, she practiced and practiced, but she was just completely overawed by the set, and she wasn't, terrible is overstating it, but she wasn't good. It didn't matter. It didn't matter because the idea was just to have her stand up there. Nothing. This is strategy, folks. It's not about making arguments. It was about looking respectable. "15 minutes to the side." The argument, instead of lasting 30 minutes, actually lasted, I think it's 59, if you watch it on the Supreme Court's website, which is a long time to be standing up there. I mean, I ended up talking for about 35 minutes, something like that, all told, which is not quite as long as you've been listening to me blathering on here, but it's getting close. And then Chenacki was argued by Jay Mackey, who's the guy who gave me that this is the case you should take line. And In Re DJS was argued by another lawyer from the Office of the State Public Defender, who's a brilliant young lawyer. She'd never been in the Supreme Court before, but she'd been doing this work for a while. She did a great job. She just knocked him dead. And when the decisions came out, piecemeal over some time, we won. We did not win Bodike. We did not win Bodike on how terrible the law was. We didn't win it on ex post facto. We couldn't get 4 judges who said it was punitive. We didn't win it on the state's retroactivity clause. And in fact, when I stood up to argue, and that's what everybody thought I was going to stand up and argue. I mean, you can see the justices, that's what they wanted to hear, that's what they expected to hear, because that's the basic argument we'd been making, that this is punitive and ex post facto, and for years we'd been saying that, and that's not what I stood up and said. What I stood up and said was this. These decisions classifying people under the old law were made by judges. You folks were judges at one time. Now you're justices. You don't do this kind of stuff anymore. As the former Chief Justice of the Ohio Supreme Court said, they call themselves justices. They said, there are no judges on this court, and there's no justice in the lower courts in this state. Which is remarkably true, but neither here nor there. But I said, but you folks were all judges at one time. You made these decisions. Judges made these decisions. And the legislature now has said, oh, but the Attorney General, who's part of the executive branch of the government, he gets to undo what you did and reclassify people that you determined belonged in these classifications. They're taking your power. Well, guess what the Supreme Court thought was important? Turf! And so they said, and this is what they said in Dodike, this reclassification scheme violates the separation of powers of our three-part system of government. The rule is counting to 4. It doesn't matter how you get there. It didn't entirely solve the problem for a variety of reasons. In Chernacki, then they dismissed Chernacki because they said, well, as long as we've decided that they can't reclassify people, they're not entitled to lawyers to help them fight the reclassification. Okay, that makes sense. And Inde DJS was another win. Brooke Burns got a great win, giving a break to juveniles who were being classified in the first place. And then along a year or two later in State versus Williams, they've done about 8 sex offender State versus Williams cases over the years. But in one of them, which was kind of the last thing that we all did as this coalition, in a State versus Williams, they finally said fully that this time they went to the Retroactivity Clause of the Ohio Constitution and said that if the offense at issue was committed before the effective date of the Adam Walsh Act, the Adam Walsh Act can't be applied. Megan's Law, yeah, that can be applied, although the Adam Walsh Act actually repealed Megan's Law. So, yeah, we can apply a law that doesn't exist. But we can't apply the law that actually does exist. That's what they said. Fine, it made a difference. We ended up making a difference for about 28,000 people around the state. And maybe 26,000 of them, 27,000, it was a positive difference. For a few thousand, it was actually a negative difference because their classification, they had been classified as lesser things or as sexual predators, and the Adam Walsh Act actually reduced their classification level because it wasn't about whether somebody thought they were dangerous, it was about what they were convicted of doing. And so there were a few people that actually hurt, which we feel terrible about, but it helped 27,000 people, and how did we do that? Well, we did that. Afterwards, we had wins and losses on some technical stuff. And the good news is the legislature hasn't made things a lot worse. Hasn't made things any better, but it hasn't made things a lot worse. A lot worse. It made things a little worse, but not a lot worse in the last few years. But the lessons of all this are that it can't be done alone. And it can't be done by just... Remember that first case under Megan's Law, State versus Cook? A few months ago, I got an email from Cook. He said, I think I'm the perfect case to undo my case. And now say that Megan's law can't be retroactive anymore either. I've got the perfect case for that. Won't you represent me? And I said, which is true, I can't. Your case is in whatever county it was, and I work in Cuyahoga County, and I can only do Cuyahoga County cases, which is true. I said, you can check with the people in your county, you can check with the state public defender, you can talk to the Ohio Justice and Policy Center, but I can't do your case. The truth is, I can't. A while later, I got another email from them that said, I'm entitled to any lawyer I want. It turns out I want you. Well, maybe you're entitled, but I can't do your case. I don't know whether he has a really good case or not. My gut feeling, without having done the research and looking into it, is no. The fact that he was the named case in 1998 does not make him a more likely candidate to get things reversed now. In fact, it probably makes him a less likely candidate. But he's in the position, and this is the problem, and this is why I'm telling you about him. He's in the position, once again, of I'm the guy who's getting screwed. I'm special. And the answer, unfortunately, is probably for him, one more time, no, you're probably not. You are to you. You are to your family. You are to your friends. But individually, no. What it takes, and I don't know where we go from here. I don't know how we legally take down this system until two things happen. You start electing people who do not believe that every criminal sentence should end up with a sentence, that every crime should end up with a sentence of life plus cancer. And you convince the people who are elected that if they treat people fairly, instead of pandering, instead of naming laws after people, if you treat people fairly, if you look at what's really going to make a difference in this world, if you notice that in fact the incidence of recidivism among sex offenders is among the lowest of all crimes. According to whom? Not just wackos like me, the ACLU, no, according to studies from the Department of Justice. According to the studies from the Ohio prison system. According to studies from the very people who we think all think you're monsters. If we start electing people who will adhere to something other than the panic of the moment, if we start convincing the people who are in office that they won't be voted out of office if they just do the right thing instead of pandering, then maybe we can get somewhere. But beyond that, it's not going to be done because you or your brother or your cousin or some guy sitting in, I don't know, Lincoln, Nebraska, is getting shafted. It's going to be done through, in the courts at least, insofar as the courts are going to help, they're going to help with systemic litigation that's not brought by one guy or another guy, but by institutions, organizations that have some support internally and that can find new and different ways of going about challenging these laws. And it's not going to be done in federal court. because the U.S. Supreme Court, for the foreseeable future, and those folks have life tenure, the U.S. Supreme Court for the foreseeable future is not going to be a hospitable court. It's going to be done state by state on the technicalities of your state laws and your state constitutions. And that means that these battles have to be fought out in 50 different states and in the Commonwealth of Puerto Rico and on American Samoa and in the U.S. military and separately in federal court. And they've got to be done that way because it's the only way we're going to get where we need to get. And we need to get there. And I can't do it alone. I can't do it even within Ohio alone. I can't do it just by organizing my little group of people alone and putting another coalition together. And we can't all do that. We can't keep those going all the time either because we've all got other things we're doing. In 2 weeks, 3 weeks, I'm going to Virginia to talk at a conference of roughly 250 of the top death penalty litigators from around the country about capital punishment law. I can't devote all my time, much as I might like to trying to take down this stuff. I've got lives I've got to save in another form, and I've got this job in the next case that comes along, and right now I've got to try and keep a case out of the Ohio Supreme Court for a guy who's about to be deported. Or at least he might be if it goes back into the Supreme Court. I mean, I've got all these other things to do, so does everybody else. We can't take all your cases, much as we'd like to, and no organization can, and certainly no individual can. Okay, I have blathered way long enough here. Do we have anybody? So. Okay, so I'm getting questions here, and I'm just going. These are not organized unless Barbara's organized them before she gave them to me. So I'm just going to do this one at a time. Thank you for listening to me carry on here. It appears there has been some excellent collaboration among lawyers and various civil rights groups in Ohio regarding sex offender issues. Do I know if there are similar collaborative efforts among lawyers at a national level? No, I don't know. I know that after we won Bodike, I got calls from lawyers all across the country saying, how'd you guys do that? And again, I wasn't the only one. I just happened to I'm the one who technically represented Bodike. I'm first on the list, me and John Alton, the local lawyer who brought us in. My name's there. It was my case only because I happened to have the random one that got in there first. It was really a collaborative effort, but my name happens to be there. I got calls from lawyers all across the country saying, "What can we do? How can we use what you did?" And I said, "I don't know. I'll send you what I've got." So I sent them our materials, all the stuff that we had filed in Bodike's case. And I put them in touch with other organizations, and in some states I know there were collaborations between the ACLU and criminal defense organizations of one sort or another. I know that. I'm not aware of any broad national, but maybe somebody else knows, and this is where there's going to be a panel discussion later with a bunch of lawyers, and maybe somebody will actually have a good answer for that. Oh. How do we work with the PDs to get greater exposure of facts for public education, raise awareness, and focus on prevention? One of the things about lawyers is that we like to talk. It's what we're paid to do in one sense or another. And there's a category of lawyers, I have to say most of them are in private practice, who think that that the smallest distance in the universe is the space between them and a microphone. It's generally bad lawyering. That's not ordinarily what you want to do. Lawyering, when I said we tried to cherry pick cases and I told you about the 19-year-old who had sex with a 14-year-old and they're now married and have 3 children, all litigation is about storytelling. The story that gets people convicted of crimes is you've done something terrible. The story that gets people convicted of bad crimes is you're a monster. I can't win cases in the ordinary course of things unless I can write a different story. Whether it's in response to the jury or it's in some later forum in front of a judge or a panel of judges or the state Supreme Court or the U.S. Supreme Court, and we just lost a case in the U.S. Supreme Court last week, 2 weeks ago. Because we didn't tell a good enough story. Some stories are about individual people, that 19-year-old young man. Some stories, good stories that is, some stories are about the law. Some stories are about the power of justices. No, you don't want them taking away your right to decide who's a bad guy and who's not. You don't want the Attorney General doing that. Oh, this is about us. Yeah, right. It's finding the story that you can sell. Telling, and this is how do we get exposure for public education? The answer is good stories. You're not going to get it from public defenders. You're going to get it, I mean, you will now and again, but they're talking. As lawyers, when we talk to the press, it's either a serious mistake or it, and mostly it's a serious mistake, or it's on behalf of this individual client and this eccentric set of facts, and we're doing it only to counteract what the prosecutors just said, or the cops have just said. We're not the voice that you need. Unfortunately, and I say this, and it really is kind of unfortunate, you need to be the voice. RSOL needs to be the voice. You folks need to be the voices because you have the stories. And I mean, we can tell them in various ways. I have a blog, I write stuff, but I won't write about any of my cases, I won't write about any of my clients. I write about other people, and I pretty much don't write about anything that happens in my county. But I write about things that outrage me. A friend of mine said that my blog should really be called Things That Piss Me Off. But I also write about things that I like. But I tell stories, and I have, I don't know, maybe 300 people around the world read them. Yeah, that's an influential audience. But the answer is you've got it. You have the stories. And unfortunately, in large part, you individually or you institutionally are the ones who need to tell them. Second question from the same person. Is there a pathway through legal affiliations to work this as a national effort in each state? I don't know how. And the problem is every state does have its own law. Every state does have its own constitution. Ohio has 88 counties. Each of the 88 counties has its own court system. And I like to say Ohio is barely a state because everything operates individually, county by county, and actually even in smaller units than that, municipality by municipality. We have a federal system with basically 51 different jurisdictions, and actually more than that, and and everyone is different and operates under different laws and different procedures, and mostly you're not going to win these cases on the U.S. Constitution, not now. You're going to win them on your state constitutions and your state statutes and in your state courts. And you can have a legal clearinghouse. It would be great to have a legal clearinghouse for this stuff. I don't think there is one. But it would be terrific for somebody to have the resources to set one up. And maybe RSOL can do that if it gets lots of resources. But that's what it's going to take, I think, because right now, no. ICE agents told me at my door, that's Immigration and Customs Enforcement, that they had a search warrant. They refused to show me the warrant until they had secured the premises. How is it legal for them to enter my house before showing me the warrant? Why isn't this challenged? I don't know why it wasn't challenged. I wasn't there. I can't do anything about that. Is it legal? The answer is always, well, sort of, maybe. The correct answer to every legal question is it depends. And it depends on all kinds of things. And can they secure premises before they have a warrant? Yes, sometimes, maybe. Can they secure them after they have a warrant? Yes, sometimes, maybe. It depends. In ex post facto considerations, can you address the relevance of the date of the offense versus the date of the conviction? Cases are often prosecuted years after the offense. Indeed, I'm actually representing a whole bunch of people right now who have, I've kind of become the specialist in our niche of the office on people who were arrested, who were charged with, Ohio just decided, it would be a really good thing, or Cuyahoga County actually started this a few years ago. We've got all this DNA from rape cases that nobody's ever bothered to look at. We've just been storing it in lockers. And so let's go and have it all tested. And so for the last few years, after 20 years or so, they've been testing the DNA and they've been bringing criminal charges against people for 20-year-old sex offenses and 20-plus-year-old sex offenses. And the statute of limitations for these offenses, which was 6 years, in 1999 became 20 years. And if your crime had occurred, if you were still within the statute of limitations, your 6 years had not run out when the statute of limitations became 20 years, yours got extended by another 14 years. So we're bringing all these cases now, and I represented a guy whose crime was committed, alleged crime. He maintains he's innocent, and maybe, but a woman was gang raped. There's no question that happened, and police knew who he was, and they investigated the case for 2 days, and then dropped it in 1993. 10 days before the 6 years from the date of the crime, the statute of limitations was extended by 14 years. 10 days after the now 20-day statute of limitations was over, he was charged with the crime. They said it was told. We won that argument in the Court of Appeals, not in the trial court, but in the Court of Appeals. The state's got that case in the Ohio Supreme Court now, and Ohio's in the process of enacting a law. I believe it was just signed by the governor, but I'm not sure if it wasn't. It's about to be. That extends the statute of limitations for sex offenses by 5 years, but if they someday somehow turn up some DNA that matches somebody, then they've got 5 years from whenever that may be. Ex post facto law says very simply, you can't make things worse after the fact, but there are so many exceptions to that law. Because the answer to all legal questions is always, it depends. Hey, if we hate you, you lose. If we like you, you win. That's the answer to all legal questions. And And yeah, there are principles, and sometimes you can make them work, and sometimes you can't, but that's kind of how it goes. Can I discuss the feasibility of expungement of convictions? It's really a state-by-state thing. The federal government does not have a mechanism of expungement. It is not possible to expunge a case in federal court. A judge in New York, Judge Gleason, a federal district judge, just did expunge a conviction. And the government, which says, you know, he was right morally, but wrong legally, we're appealing that decision. There is no expungement in federal court. So if you've got a federal conviction, forget it. If you've got a state conviction, can it be expunged? It depends on your state. It's all a matter of your local law. In some states, lots of things can be expunged. In some states, nothing can be expunged, and it varies dramatically from state to state. Why is it that a sex offender has only one type of sentence? If a man kills a person, he gets one sentence. If a man just beats up a person, he gets another sentence, according to how bad he beat the person. Sex offender is charged no matter if it's rape of a 6-year-old child or if he just talks to a police officer on the phone. Why? Because they hate you. And it's also not technically true. I mean, they are all different crimes, and the technical sentence varies. It is the soreness stuff that goes forever no matter what. And even that varies, once again, depending on your particular state's version of the law and what exactly it is. But yeah, I mean, the bottom line is, you know, more and more cases, state and federal and all kinds of crimes, our goal is, see, the theory is somehow that if we just put people away forever, then we'll all be safe. And it's not true. You know it's not true. I know it's not true. And the people who pass those laws and the judges who enforce those laws know it's not true anyway, but they don't care. They don't care because they think, frankly, because they think it'll get them votes, they think it'll allow them to move up to some higher position, whatever it is, whatever their system is, because and because, frankly, some of them are just stupid. But they don't care. You know, I mean, life plus cancer. It is said that, what's his name? Dylan Roof, right, who is charged with killing those 9 people at the church in Charleston, South Carolina on the 17th. The state of South Carolina is charging him with 9 counts of murder. They will probably, although they technically have not made a decision yet, seek the death penalty against him. There's a fair chance he will end up with 9 death sentences, presumably to be followed one execution after the next. If not, he will get 9 consecutive life sentences so that after he dies, they keep him in prison until he does it again 9 times. According to yesterday's New York Times, it appears that the Justice Department is also going to charge him with a federal hate crime, for which he can get a life sentence. Because, after all, and because they hate him. You know, I mean, there is no stopping point as long as they hate you. They hate you. That's the answer. You are the golem. I mean, you know, sex offenders are the golem. They're the monsters today, and you know, some years ago it still is in a different context. People who commit DUIs. You know, drive under the influence. The idea is to put you away forever. And frankly, those people are more likely to hurt me and my family than you know. But the truth is, they don't set out to commit crimes. They don't set out to kill somebody while they're driving drunk. I represented a guy who, unfortunately, I got into the case very, very, very late at a time when I could do nothing for him, as it turned out. And I feel it's just awful. He was driving drunk. Possibly he was asleep. Possibly he was sleep driving. There is such a thing. It does happen. But by the time we got involved in the case, it was too late it turns out. We talked to experts and did all kinds of, we just couldn't. Anyway, he ended up killing a couple of people. It was a terrible accident. He was going the wrong way on the interstate. And there's a lot of that actually that happens around Toledo, Ohio. I can't exactly explain why, but there are a lot of people killing folks driving the wrong way on the interstate near Toledo. I don't know what it is about Toledo, but it seems to bring that out. And so he was charged with killing these people, and he hired the wrong lawyer, who said, "Look, I know the judge." You know, they say a good lawyer knows the law, a great lawyer knows the judge. Don't believe it. He said, "I know the judge. She used to defend people charged with crimes," which is true. "She'll be easy on you," which is false. She hated her clients. She represented them, yeah, but she thought they were all terrible people who needed to be put away forever. Hey, it was a job. She did it badly. He said, "Just forget plea bargains, forget going to trial, plead guilty and throw yourself on the mercy of the judge. 5-6 years at the most. You did kill 2 people. 54-year sentence." Because he was driving drunk. Because that was the flavor of the time of who is the monster. It doesn't matter whether it was reasonable, it doesn't matter whether it was fair. He was the monster that day. In Texas, when should a lawyer be presented? And if you ask for a lawyer with the phrase, "I think I need a lawyer," is that legal? If you're talking about when being questioned by the police and your Miranda rights, "I think I need a lawyer," won't do it. I want a lawyer. If the police want to question you, this is the only piece of legal advice I will give you, and I will absolutely give you this piece of legal advice. I can't No, my Texas law license is inactive these days, so I can't actually practice law here. But don't tell anybody. I'm giving you this piece of legal advice. If the police want to question you about anything, you have one thing to say. You must say it, and it's the only thing you are to say. "I will not speak until I have spoken to a lawyer. I want a lawyer." Period. Now, if you are stopped while driving your car, you do have to give them your license, your registration, proof of insurance. You got to do all that other stuff. But if you are being questioned about pretty much anything, it's not because they want to help you. And the thing you need to say is, "I want a lawyer." Not, "I think I need a lawyer." That's equivocal. That's an iffy kind of thing. You can't be quiet and thereby invoke your right to silence. The Supreme Court said that doesn't work. In order to invoke your right to silence, you must speak. That's what the U.S. Supreme Court said. And what you must say is, "I want a lawyer. I will not talk without a lawyer." "I will not talk" doesn't stop them from coming back. "I will not talk without a lawyer" stops them from coming back. That's what you need to say. And that's true across. It may be that some state lets you get away with less than that, but that's. An online question. Ooh, cool. Technology, the wonders of technology. Your message is clear and powerful. "I have begun fighting cases with an excellent team in New Mexico." Good. Thanks to you and Kathy Zudi for your excellent work in Ohio. "What are my general thoughts about the Blankenship case?" I mean, we're not going to go there. Ohio law and weird, and I'll pass the word on to Kathy Zudi, though. She'll be very happy to hear that. She's a great lawyer with the State Public Defender's Office, and many people believe they can and will stay out of trouble. So no interest in real reform in the law. In the face of this view, what can RSOL and other reform groups do? You know what? Spread the word. Yeah, people believe they're not going to get in trouble. People think they're fine, right up to the point where they're not. How many of you ever expected to be prosecuted? You thought you were going to be convicted? You thought you were going to be found guilty? You thought that what you were doing was... Yeah, no! Yeah, it happens, but it's not the norm. And what's the name of your blog? Gamzo for the defense. Could I give my assessment of plea bargaining? When does it make sense? When is it the wrong thing to do? It's the wrong thing to do if you've got a case that you might actually win. It's the wrong thing to do if they don't offer you anything. There was a prosecutor in Lucas County, Ohio, which is Toledo, who told somebody, you've got 7 days to plead to the indictment, and then I'm taking that off the table and trying you for the indictment. Okay, here's your plea bargain. You can plead to everything you were charged with, or you can go to trial and maybe get convicted of everything you were charged with. Or maybe not. Which would you choose? Plea bargains are about risk reduction. And they make life easier for everybody, and I got to tell you, in many jurisdictions, certainly in Ohio, appointed counsel, not public defenders, we're on salary, not retained lawyers necessarily, but appointed counsel in many jurisdictions and in many places in Ohio, and remember we have 88 counties and 88 different fee schedules, by the time they go to trial, they've already earned as much money as they can get. Your trial is free. The lawyer representing you at trial isn't getting paid for it. That's not always true, and it's certainly, but it's too often true. And that's a problem with the system, but it's also, unfortunately, a problem because some lawyers, therefore, don't do the job right. Because, hey, I'm not getting paid anymore. But plea bargains are ultimately a system to both move the system forward because we can't try all the cases. And it can't be done. The system would crash. And prosecutors talk about it, and I'm elected, there will be no plea bargaining. And that generally lasts about a month and a half after they're elected because they can't do it. They can't try all the cases. And the judges, there aren't enough judges, there aren't enough prosecutors, there aren't enough defense lawyers. And what happens is time periods run out and the people get released without, oops, didn't mean to have that happen. They can't do it. It will crash the system. Unfortunately, the law does not allow us to all get together and organize to refuse plea bargains, and it would be a bad thing if it did because while it might help you, it might hurt you. And unfortunately, when I represent somebody, I have to represent them, not the good fight. And but plea bargains are ultimately about risk reduction. They're compromises. The prosecutor avoids the risk that you won't be convicted at all. You avoid the risk that you're going to be convicted of something more horrible and do even more time. And maybe you're bargaining over offenses, and maybe you're bargaining over sentences, but they're all about bargains and trying to keep it and trying to hold those things together. And when does it make sense? Case-by-case determinations, always. What percentage of cases, of sex offense cases, actually win? God only knows. At trial, the percentages, realistically, the percentage of cases across the country, the percentage of cases that are won, well, it depends in part on how you define win. Across the board, not guilty, Well, that's certainly a win. Convicted of a lesser offense, is that a win? Well, maybe. But across the board, not guilties in cases that go to trial across the country, probably something. In all cases, it's probably somewhere around 20%. I'm making that up, I don't know. 15 to 20%, maybe lower, and that varies dramatically from case to case and jurisdiction to jurisdiction, and sex offenses in particular, I have no idea. And it depends on the sex offense, frankly. The cases of child rape have a very different percentage outcome than the cases of something else. I mean, it's all fact specific anyhow. I think I've got one more here, but I may have missed a question along the way, and if I did, I apologize. Have I represented clients with developmental disabilities? Yes. Charged with these crimes? Yes. How do courts and prosecutors respond? Do they usually consider it a mitigating factor? Or maybe it's an aggravating factor, unfortunately. Let me tell you about Johnny Paul Penry. Johnny Paul Penry out of Texas. Johnny Paul Penry has serious intellectual disability. He was charged back in the 1980s with capital murder here in the state of Texas. He was sentenced to die. His case went to the U.S. Supreme Court, arguing that the fact that he was mentally retarded, as they called it in those days, should exclude him from the death penalty. The Supreme Court said no. His lawyers said, but his case goes back, but look, we can't even use this. Texas does not allow us to tell people that Texas asked two questions. Should he, in those days, Texas asked two questions of a jury trying to decide whether to sentence somebody to die. Did he commit the crime deliberately? The jury's already decided he committed the crime purposely. And if you can figure out the difference between doing it purposely and deliberately, good for you, because nobody else ever has been able to. But question number one is, did he commit the crime deliberately? Question number two is, does he pose a threat of future criminal violence if we don't execute him? Johnny Paul Penry has mental retardation. What's the answer? Does that make him more or less likely to be dangerous in the future? Are you more or less scared of him because of that? And the answer is, well, some people may be less, some people may be more. Does it mitigate? Yeah, it mitigates exactly to the point where it starts aggravating. That's true of all disabilities, of all developmental disabilities. It's true of kind of everything. Some things, it's better or it's worse. It depends. It depends. There I am again. And later, that was 1989 when the Supreme Court said, yeah, it's okay to execute people with mental retardation. In 2002, they changed their mind and said, no, it's not. And that's now an exclusion from the death penalty. But that same principle, how do people view developmental disabilities? Well, maybe they make you more dangerous, or maybe they make you less dangerous. So maybe it mitigates, and maybe it aggravates. Guess what? It's about, if we're doing our jobs right, we as your lawyers, if we're doing our jobs right, we're going to get the right experts to say the right things about you, and we're going to find a way to make them convincing. If we can get the resources to hire those experts. If we can't, and maybe we can't make them convincing. And maybe the prosecutor will be bringing in their experts, and maybe they won't. But ultimately, what are we doing? We're telling a story. I'm going back to that because I really do believe that litigation is all about storytelling. And I teach this at seminars occasionally. It's about storytelling. And what I want to do when I represent, because this starts with, have I represented people this way, is I want to tell a story. And I want to tell a story about how, because of your people with developmental disabilities, I want to say, you know what? There's a reason that you did this. It's not your fault. It's not entirely not your fault. I mean, if you committed a crime, you committed a crime, and and I'm not saying it's referred to sleazily as the abuse excuse, and it's not an excuse, but it does say, if we're going to punish people for fault, we don't punish them for who they are. We punish them for what they did. And what they did within the context of how it is that in this world they became that and did that and whatever it is. And there's a reason for this. And if we understand the reason, then we understand the person. And if we understand the person, then the person isn't a monster anymore, he's a person. I don't represent monsters. The government thinks I do. The public thinks I do. I don't represent monsters. I represent people. And you are just like all those folks out there. You got caught up in the system. They get caught up in the system. But you know what? It's just like those folks out there. We're all in this together. And I represent people. I don't represent monsters, but it's monsters who get tried, it's monsters who get convicted, and mostly it's monsters who get sentenced. And if we're doing our job right, what we're doing is we're trying to convince the jury, the judge, the appellate judges, and frankly the public out there that we represent people, not monsters. Last question. I understand that mental health issues are currently mitigating factors, mostly, yeah. However, today, how has it ever been considered an aggravating factor? Because you're monsters. Except you're not. Thank you.
Thanks so much, Jeffrey. A lot to think about there. We do have a couple of very good, very interesting workshops coming up right now.